Obamacare could be headed back to the Supreme Court. And joining me today are two men helping to make that possible. Over here we have Jonathan Adler, law professor at Case Western Reserve, and Michael Cannon, who's the Director of Healthcare Policy Studies at the Cato Institute. Michael, I want to start with you for a bit. Basically, if you can start and sort of sum up for people that have maybe seen headlines about Obamacare back in the courts and aren't really familiar with the lawsuit, what the lawsuit is actually challenging, and if you can say how you guys kind of got involved with being alternatively the evil geniuses or intellectual architects, depending on your perspective, behind this latest slate of legal challenges.
Well, Obamacare directs states to create health insurance exchanges. These are regulatory bureaucracies, and the exchanges are where the law makes available its health insurance subsidies to help people purchase the often very expensive coverage that the law mandates that they purchase. But the statute says that those subsidies are available only, quote, through an exchange established by the state. The statute actually says that a couple different times. It's very clear that the subsidies are available only if the state establishes an exchange. Now, if a state doesn't establish an exchange, the federal government is directed by the statute to establish an exchange, but there's no authorization for those subsidies. So what has happened is, and there's nothing out of the ordinary about this. Congress does this sort of thing all the time. It cannot force states to implement federal programs, so it offers them incentives. It did so elsewhere in the Patient Protection and Affordable Care Act. It does so all the time. So what's different about this situation is that 36 states refused that role that the authors of this law envisioned for them. They either refused or declined or failed to establish a health insurance exchange. And so the federal government had to step in and create exchanges for those 36 states. Now, under the statute, that means that those subsidies are not available. And that would spell trouble for the statute, because the purpose of those subsidies is to hide the cost of the health insurance that Obamacare requires people to purchase by shifting much of the premium, often on average about $5,000, from the premium payer to the taxpayer. If those subsidies are not there, then people would be facing the full cost of this very expensive coverage, and you might see an even greater backlash against the law than we have seen to date. In addition, those subsidies, because of the complicated interrelated machinery of Obamacare, those subsidies trigger penalties against employers under the law's employer mandate and against a lot of individuals under the law's individual mandate. And so in those 36 states, what should be happening is the federal government should not be issuing any subsidies, should not be subjecting employers to the employer mandate, and should be exempting, by my count, about 8 million individuals from the individual mandate. But that's not what's happening. The Obama administration back in August of 2011 announced that it was going to issue those subsidies in all states, whether they had a state-established exchange or a federal exchange. And so that's, and Jonathan and I pointed out back in 2011 that they didn't have the authority to do this. They've been criticized by members of Congress and others ever since. But they, in January of 2014, they started issuing those subsidies in the 36 states with federal exchanges and subjecting, and about 5 million people received those illegal subsidies. And they also simultaneously started subjecting about 250,000 employers and tens of millions of individuals to the individual and employer mandates in the law from which they are statutorily exempt. So that is what gave rise, that decision to offer those subsidies where the statute does not authorize them is what gave rise to these 4 lawsuits, including Halbig v. Burwell, where we got a ruling against the federal government, saying that, in fact, yes, those subsidies are illegal, and the president is violating the law by taxing and borrowing and spending tens of billions of dollars he doesn't have any authority to touch.
Okay, Jonathan, if we could look at where the legal path is, because ultimately, if the challengers are going to beat the administration, it's going to have to be resolved by the U.S. Supreme Court. So right now we have a split among the circuits. As Michael mentioned, the D.C. Circuit Court of Appeals sided with the challengers and said that the rule by the administration delegating these subsidies to the federal exchanges was illegal. But you also had a ruling the same day in the Fourth Circuit that said it was a reasonable interpretation of the statute and that sided with the administration. So right now you have in the Fourth Circuit, the challengers are asked the Supreme Court for a hearing, whereas the Obama administration is asking for the whole D.C. Circuit to rehear the case. Now you clerked on the D.C. Circuit. Could you just give us a little bit of insight into what goes into considering whether the court will rehear the case, and how do we get sort of from here to the Supreme Court?
Sure. Okay, so we have, as you mentioned, we have these two decisions. They're conflicting decisions. They create what we often refer to as a circuit split. That is, different circuit courts of appeals have reached opposite conclusions on the same underlying question. Typically, the way you resolve a circuit split is to seek Supreme Court review. And the Supreme Court, the vast majority of the cases the Supreme Court takes in any given year are cases in which the court is resolving a split among lower courts. And the plaintiffs in the Fourth Circuit case, in which the government prevailed, have filed a cert petition with the Supreme Court that will be acted upon this fall. So this fall, the court will consider whether or not to accept that. In the meantime, in the D.C. Circuit, as you mentioned, the federal government has sought to get an additional layer of review before a potential Supreme Court challenge. They have asked for what's referred to as rehearing en banc. So initially, each of these cases is heard by a 3-judge panel. The en banc court is the whole court sitting as a whole. So in this case, it's the 11 full-time judges, or active, what we call judges in active status, plus the 2 senior judges that participated in the original panel. So those 13 judges. Traditionally, petitions for rehearing en banc are highly disfavored. The D.C. Circuit typically doesn't grant more than 1 or 2 a year. It had 2 this year, had 0 last year. They're very rare. The federal government is arguing that the D.C. Circuit should take this case to eliminate the circuit split and eliminate any need for Supreme Court review. And that's certainly an argument that the Federal Rules of Appellate Procedure recognize as one basis for en banc review. What's interesting in the D.C. Circuit is that the circuits don't have any set rules about what requires them to take or not take a case en banc. It's really something that they can exercise their discretion on. And the D.C. Circuit historically has been very reluctant to grant rehearings en banc, even in the context of a circuit split. So while the Federal Rules of Appellate Procedure allow the D.C. Circuit to do this, if one looks back at what the D.C. Circuit has done for the past 10, 20 years, it really hasn't taken the invitation to go en banc on this sort of case. Typically, what the D.C. Circuit has reserved en banc for is to address an underlying legal question, like what the appropriate constitutional standard is in a given area of law that could cut across a wide range of cases. Here, we're talking about the application of one provision or one question under a law that really only implicates this single issue. And so it isn't the sort of case that what the D.C. Circuit would normally take. Now, there are some new judges on the court, and these judges may view the role of en banc differently than the predecessors. What the D.C. Circuit has done historically doesn't necessarily control what it does in the future, but it is interesting that we don't see a lot of cases in the last 20 years that would seem to justify or provide a precedent for taking this rehearing en banc. And one thing we do see, both in the D.C. Circuit and other courts, is judges saying that what en banc is not for is simple error correction. That it's not enough that a majority of the judges on the court simply think that the decision was wrong, that rather it has to implicate broader questions to justify saying to a 3-judge panel that their opinion needs to be overturned. And so that's something that we'll see the D.C. Circuit's response to in the coming weeks. The response to the en banc petition is due at the end of the week, and then at any point thereafter, the D.C. Circuit could vote on whether or not to rehear the case.
Okay, now following the case, it seems like there's a lot of confusion out there about what it's challenging, what the specifics of the case are. I know even some prominent news organizations, for instance, have said things such as that a decision would strike down Obamacare, when in fact the issue is that the challenging is that the IRS misapplied Obamacare, illegally interpreted Obamacare. Jonathan, I'll start with you, and maybe Michael, if you have anything to add about what you see in the media that really irks you or you feel like misunderstands what you're arguing or what the case is.
Well, I think the first thing to understand is that this case in some respects is more Hobby Lobby than NFIB. What I mean by that is this is a case about the administrative implementation of the statute. It's not a challenge to the statute itself. It's not a constitutional claim. It's not a claim that Congress overstepped its bounds. It's a claim that the executive branch, in trying to implement the law and issue regulations to make it operate, has exceeded the authority that Congress gave it. This is similar to, again, in Hobby Lobby. It was a statutory claim, a claim that in administering the law's requirement for a provision of preventative care, the administration had violated other statutory constraints. And this is the sort of challenge that we're actually going to see lots of in the years ahead. This is a very large, complex statute. There will be lots of litigation challenging HHS, challenging the IRS, challenging other agencies that have a role, arguing that they're either implementing the law too aggressively, not aggressively enough, or otherwise in conflict with the law. And you're right that a lot of media folks misunderstand that. They assume that since most of the challengers are folks that have been critical of the law, were upset with its passage, and perhaps even supported the challenge to the mandate, that this must be a challenge to the law itself, as opposed to the challenge to the way it's being implemented. And the way I usually respond to that is that we could say the law was bad enough as passed, but what we're getting is actually not what Congress authorized. What we're getting is something else, and that not only raises policy questions about what sort of healthcare reform we should want, it raises broader legal questions about the nature of executive authority and about what agencies are allowed to do with or without congressional authorization.
Do you have
So yeah, a lot of people are saying that this is a challenge to Obamacare, and it's really not. As Jonathan said, the plaintiffs in these cases are trying to uphold the statute and prevent the administration from exceeding its authority and implementing parts of the statute where it doesn't have the authority to implement them. Now, a lot of people will say that that will gut the statute. In fact, it won't gut the statute. It'll just force the administration to implement the statute as written, as Congress intended it. But what they mean when they say it'll gut the statute is that without those subsidies to hide the cost of this expensive health insurance from consumers, then a lot of those consumers will stop buying health insurance. They'll be healthy on average. They'll be healthier than average. And that could cause insurance premiums to rise even further, or that could cause insurance premiums to rise, and then even more healthy people will drop out of the market, and you get what economists call an adverse selection death spiral. And that's what supporters of the law are concerned about. That's why they think it would gut the law. It's not really the law. It might gut the regulatory scheme. If they cannot hide from consumers the cost of this coverage, you might get a political backlash against the law. But that's not a result of these lawsuits. That's a result of the law itself. If adhering to this law leads to that sort of a backlash against it, well, that means it's not a very well-written law, and the Congress should reopen it. So that's what supporters of, you can't really call them supporters of the law at this point. Supporters of the Obama administration in this litigation are trying to avoid. They're trying to avoid really letting the democratic process work the way it should when confronted with a bad law.
Now, what do you think are some of the other policy implications if this gets upheld, if the Halbig decision of the D.C. Circuit gets upheld by the Supreme Court?
Well, it would probably force Congress to reopen the law. I mean, at the end of 2013, when all sorts of people were getting cancellation letters in the mail saying that their plan is not compliant with the Patient Protection and Affordable Care Act, and so they're going to have to buy a more expensive plan, a lot of people were very upset about that. And that was about 5 million people tops were getting those cancellation notices. Well, here you would probably see even more people who were upset because either their premiums are going up, or either because they're losing a subsidy, or because insurers are dropping out of the market because they have decided, they see the adverse selection death spiral coming. And you would get lobbying not just from, or you get political pressure put on members of Congress from consumers, from insurance companies. It would make the backlash against the president breaking his "if you like your health plan, you can keep it" pledge look like a hiccup. And I would imagine that even Democrats would be open to reopening this law, and repealing the law would become feasible at that point. Even with President Obama wielding the veto pen, it might not happen, but it would become feasible. And at a minimum, Congress would have to do something to remedy this problem that the PPACA created.
Now, Jonathan, one of the big issues in this case hinges on the idea of the plain reading of the text, which says that the subsidy should flow to exchanges established by the state, versus this idea of congressional intent and legislative history. And the idea of how courts kind of weigh the importance of legislative history. Ultimately, the D.C. Circuit said the legislative history is kind of silent to muddled, so we have to default to the plain meaning, whereas the Fourth Circuit looked at it differently. Could you sort of describe that tension?
Sure. So, I mean, typically in interpreting a statute, courts are to begin with the text of the statute. And you initially look at the clear language, you look at the structure, you look at the context of that language. And the question the court is trying to answer in a case like this is, did Congress speak to the precise question at issue? Did Congress tell us whether subsidies are authorized in federally established exchanges? And the reason that's important in a case like this is because an agency like the IRS doesn't have its own residual inherent authority. It only has that authority that Congress has given it. It can only recognize tax credits that Congress has authorized. And so the initial entry point is did Congress answer that question? Now, there's some debate among judges and among legal scholars about what you look at in answering that question. Everyone agrees you should start with the text. Now, we didn't always agree with that, and admittedly there are some academics that think you should set the text aside. But then the question is, what do you do beyond the text? Do you look at floor statements? Do you look at the drafting history? And do you look at the broad purpose of the statute? The D.C. Circuit's view, and I think this is the traditional way the D.C. Circuit historically has looked at statutes, and the way most courts look at statutes, is to say these other sources of meaning are things that help us fill in or flesh out things that aren't entirely clear. But they don't allow us to subvert the text, ignore the text, amend the text. And there's a difference between saying, you could have a word, another case that both the D.C. Circuit and the Supreme Court dealt with, you could have a word like pollutant. And does pollutant mean anything that's spewed out of a car or out of a factory? Does it mean only things that have certain types of health effects? Does it mean things that are regulated or classified as pollutants? The word by itself is susceptible to multiple different meanings. And so the court might look at the structure of the statute, how the statute operates, to try and help figure out precisely what that word means. In this case, you have a phrase like established by the state, and that's a hard phrase to do something with. And the federal government has given up trying to argue that this was a mistake. This was what we call a Scrivener's error or something like that, because the legal standard to ignore the text in that sort of context is very, very high. Instead, what they've tried to argue is that established by the state doesn't really mean established by the state. It was just a shorthand or a longhand way of simply saying an exchange in a state. The Fourth Circuit found that at least to be plausible enough to defer to the IRS's interpretation. The majority in the D.C. Circuit said, no, that's not plausible because the phrase established by the state is a very clear, direct phrase, and there's nothing in the statute that contradicts it. There's nothing in the statute that makes it inoperable, and there's nothing in the other things that we can look to discern meaning that suggests established by the state is anything other than what it means. One thing that Michael and I have been pointing out now for about 3 years is that there's not a single contemporaneous statement that anyone has identified saying simply that tax credits would be available in federal exchanges under this bill. And so the D.C. Circuit said, well, we don't even have a member of Congress or a member of the Senate saying, or even a news report saying the statute means something other than what it says. So we therefore have to go with what Congress actually enacted, even if, given that 36 states have refused to implement the law, or this portion of the law, that produces results that Congress might not have wanted or might not have anticipated when they enacted the law.
Now, Michael, you followed the law very closely from its development through the legislative process. And one argument that gets thrown out a lot toward proponents of this theory by liberals and critics of this idea is that people like you weren't out there in early 2010 saying that there was this element of the law that incentivized states to set up exchanges by saying that they were going to withhold subsidies if they didn't set up their own exchanges, and that there were no subsidies flowing through federal exchanges. And you hear a lot of this, that you weren't arguing this at the time. So what do you do? How do you respond to that argument that sort of it's absurd to think that Democrats who wanted to expand health insurance would set up a system that would deny subsidies to people?
Well, there are a number of ways to respond to that. One is that's exactly what they did elsewhere in the law. They admitted they did this elsewhere in the law. The Medicaid expansion in the PPACA, as written, would have if they didn't expand their Medicaid program. So here you had proponents of the law threatening to withhold health care from the poor unless states played ball, unless states implemented a federal program. So we can't say that this is out of character for the people who did this. As for why I didn't notice this at the time and why I wasn't arguing about this at the time, there are a number of reasons for it. One of them is, as Jonathan Cohn of the New Republic said in January of 2010, the exchanges didn't receive much attention because they weren't a hot button issue like abortion or the public option. If you'll recall, there were a lot of hot button issues that were being debated throughout 2009 and 2010, and exchanges just was not one of them. And that's also the case after the law was passed. If you'll remember, state attorneys general and others started filing challenges to overturn the entire law within hours of it being signed by the president. And for a couple of years after the law was passed, that's what most everyone was talking about, were these challenges to the individual mandate and the Medicaid mandate. And even though, and that's why it took people like Jonathan and me a long time before we even learned about this provision of the statute. We were focusing on other things. But another reason that people weren't focused on this part of the law, or two more reasons really, is one, everyone assumed that all states would establish exchanges. Or I should have mentioned that the first one is that this was a routine thing for Congress to do. It was not a big deal. But probably more important, number two, is that everyone expected all states to comply. Everyone expected all states to establish exchanges. And you see this if you look through the congressional record, if you read contemporaneous news stories, everyone expected all states to establish exchanges. It was a rarity that someone questioned what would happen if states didn't establish exchanges.
So this is how you'd explain how the CBO, for instance, in its scoring of the bill, assumed that all 50 states would have exchanges.
The CBO looked at various versions of Obamacare. The House passed bill. The bill that was passed by the Senate Finance Committee, the Senate Health, Education, Labor, and Pensions Committee, the bill that was the product of those two latter bills being merged together. And despite different statutory language and a recognition that by everybody that Health, Education, Labor, and Pensions Committee bill did withhold subsidies from states that didn't implement part of the law, the CBO still, for all of those bills, despite different statutory language, expected that all states would, that subsidies would flow into all states, which means they expected all states would implement those bills. And so that really explains why no one was looking at this. And in fact, Jonathan and I did research on this in 2011 and 2012. We didn't even publish our research until after the Supreme Court ruled on the individual mandate case, because we thought it would just be moot. It was really a minor issue until the Supreme Court ruled on the individual mandate and upheld that part of the statute.
And if I could add, there are lots of provisions in the law that didn't get a lot of attention because either of assumptions about how the law would operate or because people simply weren't paying attention. A good example of that is the income floor for subsidies, even in states that establish their own exchanges. The way the law is written, you can be the poorest of the working poor and you're ineligible for subsidies. You can be too poor to get help buying health insurance. Well, why is that in there? Well, it's in there because they assumed that every state would accept the Medicaid expansion. So and the Medicaid expansion would go to people with 133% of the federal poverty level. So cutting off people below 100% of the poverty level from subsidies wouldn't be a problem. Those folks would just go to Medicaid.
You're talking about the exchange subsidies.
Right, the exchange. And so the fact that if a state denied the Medicaid expansion, and even with an exchange, the poorest of the working poor would get no benefit from the statute is something that people didn't talk about when the law was passed. It's something people didn't talk about even after the Supreme Court struck down tying the Medicaid expansion to historic Medicaid funds. Because at that moment, it became much more plausible for many states to refuse the Medicaid expansion. And still, the same folks that are criticizing us now didn't point out that one consequence of refusing Medicaid expansion is that the poorest of the poor get no benefit because even if they have a job, even if they want to buy health insurance, they're ineligible for the tax credits, where someone who makes more money is. So there are lots of things about the law that we not only had to pass to see what was in it or to discover, but actually had to see, try, and implement.
And I think it's worth noting that we did a lot of research on the legislative history. We looked at the congressional record, months and months of what people were saying about this law. We looked at contemporaneous news stories, committee markups, different versions of the bills. The only 3 times we found before passage that anyone considered what would happen if states did not establish an exchange were the following. Representative Michael Burgess, a Republican of Texas, said if states don't establish exchanges, the federal government will, and we'll get a public option. That had nothing to do with whether the subsidies would be available or not, so that was not on point. But Max Baucus, the second one, Max Baucus, the lead author of the PPACA, said in a committee markup when he was challenged about how does the Finance Committee have jurisdiction to tell states to establish exchanges, which is what his precursor to the PPACA did. That lies out, health insurance, that type of health insurance regulation lies outside of the Finance Committee's jurisdiction. He said that this bill offers tax credits and it places conditions on those tax credits, and tax credits are in the jurisdiction of this committee. So he admitted that his committee was using the conditional nature of the tax credits as a jurisdictional hook to be able to tell states to establish exchanges. And finally, and I think most clearly, when in the brief span of time between when the Senate passed its bill and the people of Massachusetts elected Scott Brown to the Senate, a Republican who denied the Senate Democrats the 60-vote supermajority they would need to get a compromise between the House and Senate bills back through the Senate. In that window of time, when they were still debating how are we going to reconcile the House and Senate bills, 11 Texas Democrats wrote a letter to Nancy Pelosi and Barack Obama where they said that we don't like the Senate bill for a number of reasons, and one of them is its approach to exchanges. Its approach to exchanges is like the state children's health insurance program, where if a state doesn't implement it, its residents don't see any benefit. They said if we go with the Senate approach to exchanges, we will get the same result. Millions of people will be left no better off than before Congress enacted. So here you have members of Congress, Democrats, looking at the provisions that we're now debating and saying, this is just like all these other conditional programs that we've created. So now that's the exception to the rule that everybody thought all states would establish exchanges. When we found people who thought that maybe states wouldn't establish exchanges, they were very concerned about the PPACA because it does allow states to block those subsidies if they decide not to cooperate.
Okay, and Jonathan, one term that gets thrown out a lot in the legal arguments about this is something known as the Chevron test, or Chevron step 1 or step 2. For people who aren't lawyers, could you explain what that means and what its relevance?
Sure. So the Chevron doctrine is a doctrine that comes from a case from 1984 called Chevron versus NRDC. Okay, and the question is, how should courts interpret statutes that are being implemented by federal agencies? And the Chevron doctrine outlines a two-part test. The first step is the court is supposed to look at the statute itself and see if the statute directly addresses or answers the question at issue. If so, the court follows the statute. That's the end of the discussion. The law is what the law says. And at that point, that the court is on its own supposed to engage in that sort of de novo interpretation of the statute. If, however, the court decides that the statute is ambiguous, and the court has other reasons to believe that Congress delegated authority to the agency to resolve that ambiguity, then the court is supposed to uphold any agency interpretation of the statute that is reasonable and consistent with the statute, even if it's not necessarily the best interpretation of the statute. So here, what a lot of folks defending the IRS rule are arguing is that, well, the statute is so complicated, it's therefore must be ambiguous, therefore the IRS gets to do what it wants to do. And the reason the DC Circuit rejected that is the DC Circuit basically said, just because a statute is complex, and just because a statute isn't perfectly designed, doesn't necessarily make it ambiguous. And it's not whether or not the statute is ambiguous anywhere, it's whether it's ambiguous about this precise question. So the fact that there are many portions of the Affordable Care Act that are ambiguous isn't what's relevant. What's relevant is it ambiguous on this point? The DC Circuit felt that when it on its own looked at the statute, it wasn't, but the Fourth Circuit took the other view. The Fourth Circuit said, well, we see conflicting arguments, we see conflicting evidence about intent and about what the statute might mean, and it's not clear that if we take the statute literally, it would work the way folks wanted it to work, so we'll assume that's ambiguity. And so they decided it was ambiguous, and then therefore the IRS could interpret it. The one issue that the courts haven't really addressed, but is in the case law, is that even when agencies are interpreting a statute and trying to take advantage of the Chevron doctrine, they're still supposed to engage in what we refer to as reasoned decision making. That is, they're supposed to explain to the public in the Federal Register why it is they're making the choices they're making, what is the legal basis for those decisions. In this case, the IRS actually didn't do that. The IRS gave a fairly conclusory paragraph just saying, well, there's nothing in the law that says we can't. And typically, if courts were to get beyond this initial question what the statute means and to look at what the IRS did, that's something that, at least in the DC Circuit, would normally raise a lot of red flags, because we expect an agency to not simply say, oh, the statute's a mess, just listen to us. We expect the agency to actually go through serious legal analysis. And if you look at, say, the behavior of other federal agencies, say the Environmental Protection Agency, when it's claiming the Clean Air Act allows it to do various things with greenhouse gas emissions, the EPA traditionally issues substantial legal memoranda explaining why they think the statute allows them to do certain things or not, what parts they think are ambiguous and give them flexibility and what parts don't. Here, the IRS did none of those things. In fact, the arguments that the government's making today in court show up nowhere in the rulemaking proceedings, nowhere in any of the IRS's own internal documents. They're really all post hoc rationalizations. And that's something else that I think, from an administrative law perspective, raises a lot of concerns. It's something that courts haven't really directly addressed yet.
And the IRS didn't even offer any real legal theory for justifying its decision to offer those subsidies through federal exchanges until they were challenged in court, until they had to respond to a lawsuit that had been filed by the Attorney General of Oklahoma. But I think it's even, the IRS's behavior here is even more troubling than Jonathan suggests. It's not just that they were silent when they made this decision and didn't offer a reasoned basis for making that decision. But staff for a Congressional Oversight Committee got to interview about 7 Treasury and IRS officials about this. And in the report that they produced, they said that those 7 Treasury and IRS officials told them that when they were writing this regulation, they knew that the statute did not give them the authority to issue these subsidies in exchanges established by the federal government. And so, and somehow, or for some reason, they then, they went ahead and did it anyway. In fact, it's interesting. People have criticized us because we didn't know about this part of the law until mid-2011 or early 2011 for you. It turns out the IRS didn't either. The IRS didn't learn about this provision of the statute. They didn't learn about this provision of the statute that they were implementing until March of 2011, 1 year after the statute passed. And what's interesting is the oversight staff have looked at the draft regulations that the IRS was putting together to implement these subsidies. And those regulations included the language established by the state, an exchange established by the state, until the IRS said they learned about this provision, and then that phrase drops out of the regulations. It disappears from the regulations. So it's even more troubling than they didn't offer a reasoned basis for this decision. It appears that they knew that they didn't have the authority to do this, and they did it anyway, which is one of the reasons that I've called for more investigation into this, so we can find out exactly how they made this decision.
Mm-hmm. Now, Jonathan, if the Supreme Court decides to hear it, what type of timeline can we expect the whole issue to be resolved?
Well, it really depends when they take it. The earliest they could really take it is this fall. The Supreme Court won't consider petitions for certiorari until it comes back from its summer recess. The first orders will be in early October. And so that's the earliest the Supreme Court could decide to take the case. If the DC Circuit accepts the petition for rehearing en banc, it's certainly possible the Supreme Court will wait until the resolution of that to even consider a petition for certiorari. There's no deadline the Supreme Court operates on. It's allowed to what we call hold over the petition for certiorari week after week without either rejecting it or accepting it. But realistically, the earliest the Supreme Court could hear this case is the spring of next year. If they decide to wait for the DC Circuit, if the DC Circuit goes for a rehearing en banc, or if perhaps even decides to wait for some resolution of the lawsuits pending in Indiana and Oklahoma, we could see something in fall of 2015 or perhaps even 2016. So while lower courts up till now have recognized the importance of resolving this question and the fact that however it comes out, states would like to know, people purchasing health insurance would like to know, health insurance companies would like to know, the Supreme Court is not under any formal obligation to try and hurry the case along.
But so the earliest would be probably sometime next June where we'd get a final decision.
Yeah, if the court accepted the case this fall, well, the normal operating would be if it accepted this fall, it would then go to the end of the line in terms of when oral arguments would be held, and then that would be a decision no later than the end of June 2015. The court has the option of accepting a case and giving it an expedited hearing schedule. The court has done that before. It sometimes does that with election law cases because it wants to make sure that the election law is clear before the next election cycle begins. So the court could accelerate it, but the normal practice would be to hear it where it comes up on the calendar, which would probably be at the earliest, early 2015, resolution later that spring.
Okay, well, it's certainly something we'll be eagerly awaiting. Thank you both for your time, and thank you for joining us for another edition of Dialogue. See you next time.